Hi, I'm Michael Warren, and this is my presentation for protection against discrimination in the workplace. To begin, let's explain workplace discrimination a little bit. Title VII, which was enacted in 1964 during the Civil Rights Movement, protects classes based on the following: sex, gender, race, national origin, color, and religion. Sex includes pregnancies and sometimes includes gender identity and sexuality, though that varies by state, which I will get into in just a few minutes. Evolving laws show that over time discrimination shifts. For example, in the 60s, you get a lot of racial work laws, and then those evolve over the decades, and you also get age discrimination, specific religion, and later LGBT laws, and so on and so forth. Discrimination can be intentional or unintentional. With intentional discrimination or disparate treatment, the applicant must prove the prima facie requirements that they're a member of a protected class and that they applied for, were qualified for, and rejected from a certain position. Unintentional discrimination or disparate impact, the applicant is adversely affected by the actions of the employer. The EEOC, or Equal Employment Opportunity Commission, is the federal agency that monitors compliance with Title VII. Their data shows that in 2013 there were 93,727 total charges, showing that discrimination is still very much a prevalent issue in the United States. Over 20,000 of those charges were for sex and race individually, and those are the most frequent charges. Because we hear so much about sex and race, I wanted to take a minute to talk about more recent issues, with age being one of them. Age discrimination issues arise because of experience or retirement age, and they're routine regardless of legality. So young people face it, and old people face it, and it's a good thing there are laws. The Age Discrimination in Employment Act in 1967 prohibits discrimination of people that are 40 and above, and although it is enforced by the EEOC, it is not nearly as effective as Title VII. There were 23,000 cases in 2010, making it one of the most frequent charges along with sex and race. In 2011, Mr. Bobby Nickel, a 66-year-old Staples employee, was fired by his employer. Mr. Nickel claimed that the manager wanted to discharge older and higher paid employers despite his receiving positive reviews for 9 years. He was the regular butt of jokes because of his age, and as well as false accusations, one of those being he was suspended for taking a 68-cent bell pepper from the Staples cafeteria. The defense to this was Staples' zero tolerance for theft and misappropriation. He was frequently harassed because of his age by younger employees, and the verdict of this case was wrongful termination. The jury very much sympathized with Mr. Nickel. The lawyer put it best when he said that hopefully this puts employers on notice that they cannot discriminate against employees based on age. And this was the largest award of its kind in Los Angeles history, with $26 million going to Mr. Nickel. Mr. Ali Abu Bakr, who is a Muslim American citizen and former Tunisian native, claimed religious discrimination when fired from Washtenaw County in 2008. He claimed to have been passed over for promotions and fired because of insubordination, refusing to work 5 minutes before his shift. Also, negative stigma surrounding his appearance, his name, caused ethnic slurs with his co-workers, and therefore he sued on basis of religious discrimination. The jury was also sympathetic, and they awarded him nearly $1.2 million. And whether or not this is legitimate is up in the air. It could be someone just using the system to their advantage. There were various reports of him being an ineffective worker, but he must have done something right. Now, the basis of my presentation is LGBT discrimination, And it's important because there is a lack of legislation in the United States, with over half of the country having no legislation. The variations in states that do provide protection vary because some states recognize gender identity, some don't, and that needs to be addressed in our nation today. LGBT is growing as a discriminatory group. There were over 1,500 charges filed since 2013. Romer versus Evans in 1996 was the first Supreme Court case to address gay rights in Colorado in 10 years. At the time, Amendment 2 was enacted, which prevented any city, town, or county from recognizing LGBT individuals as a protected class. This was passed because of opposition to affirmative action based on sexual orientation. The ruling of this case was that Amendment 2 was unconstitutional, and now the state of Colorado provides protection for sexual orientation and gender identity. And this is one of many influential cases for gay rights. Below is a map showing state by state which states allow protection for sexual orientation and gender identity. Please note that most of the states that do not provide legislation are in the South and mid to Northwest. Also note that among those states is North Carolina, our very own. To further analyze, I wanted to take one state from each category. The state of Maryland added sexual orientation as a protected characteristic in 2001, and although there are no explicit laws based on gender identity, there are 4 local ordinances to protect gender identity, with Baltimore being one of them. And these apply only to state employees, and a patchwork of protections result in different remedies. So a con for this is that approximately 9,200 transgender people live in a locality that is not protected. Statewide law would create clear requirements, procedures, and remedies for any state in the nation, not just Maryland. New York was the first state to enact the human rights law, and it does not cover gender identity, although there are local ordinances there as well, although they are not as strong as the human rights law. In New York, there are approximately 2,400 transgender people not covered in localities. The state of South Carolina provides no legislation protecting sexual orientation or gender identity, and currently there are over 100,000 LGBT adults in South Carolina. A 2013 Pew Research study confirms discrimination in the state, with 21% of LGBT workers treated unfairly by employers, and 78% harassed at work. The study also shows that same-sex couples earn less, and that negative attitudes persist in the workplace. Obviously, change is needed. Other states with no laws include North Carolina, Georgia, Florida, Arizona, and Texas. So these are particularly southern. Nationally, 37% report experiencing employment discrimination. Today, LGBT complaints are roughly equal to the sex-based complaints by women. As you'll see on the chart below, the highest numbers persist with employees who are open at work. This affects lower wages, lack of promotions, and obviously harassment. A good reason for lack of legislation is House opposition. John Boehner put it that this will increase frivolous litigation and cost American jobs. This attitude is counterproductive and provides inconsistent legislation by state. Anti-discrimination laws should protect minorities and should not deny protection to a specific minority. In conclusion, there should be statewide laws protecting sexual orientation and gender identity. This would provide protections in employment and accommodations, and clear non-discrimination requirements, procedures, and remedies. And this would cause a consistency of law and progression toward equal treatment. Really quickly, here are my sources. I'm Michael Warren. Thank you for listening.